So my background, I have a degree in chemical engineering, and then I worked in software for about 5 years before I went back to law school. The dark side, as I think many people call it. But so I'm an IP lawyer that covers everything from patents, trademarks, trade secrets, copyright. I do a lot of work in open source software, and have been practicing for close to 20 years at this point. Represent clients of all different sizes: entrepreneurs, startups, Fortune 100s. So some clients you might know: Champion, the clothing company, is my client. Pentair, SPX, which is a bunch of robotics and HVAC. Toyota, I think probably most people have heard of them. So manufacturing, software, all kinds of different things. IP is fun because there's really two parts to it, right? One is sort of the fun side, which is helping you guys and companies protect your innovation, right? That's the fun part. Then the not so fun part is, on the flip side, making sure we don't infringe other people's IP rights, right? So AI kind of sits in the middle of this, which is why it's so cool. So I'm at a firm called Husch Blackwell. There's about 1,000 attorneys nationwide. I am chair of our AI practice group from an IP standpoint. So spend pretty much every week talking about IP or AI and IP at this point. I know about IP and AI. So the fun thing about AI is it really does sit in this interesting area. If you just zoom out for a second, AI leverages information that's already in the world. Right? Fundamentally, that's the definition of AI. And so I think just as a threshold question, wondering, okay, I'm using, what am I using AI for? And I think we had some questions or comments over here. Do other people have those ideas? Most likely, yes, right? You by definition, AI and those large language models that Will was talking about, that uses information that we already know. Right? So what's that dividing line between, where we're trying to help and get ahead versus truly something new and innovative, right? And that's not to say, first of all, there's plenty of successful businesses that have products or services that are already out there, right? But maybe it's first to market or not protectable or whatnot. So it's not to say that it wouldn't be useful, but just sort of understanding the genesis of AI, right? The fact that it is based on existing information in the world. Right, and so going back to, I think, Will's example with his Z-bike is such a good one, right? And so he put in all of those different prompts about, what should I ask, ChatGPT? So we can talk about that. What should you ask ChatGPT, right? Like the actual questions, and from a legal standpoint and why it matters, right? So the first thing is you can ask it things like, how do other people solve these problems? Or, hey, what are the problems with electric bikes right now in the world? Right? Who are the major competitors in that market? What do they sell their bikes for? Right? You can use it to do all of that market research that Will was talking about. That will save you tons of time. Right? So it's all of those steps to help you get your business orientation right and your business case. Right? So that's clear cut, easy, and really doesn't have anything to do with your own intellectual property, right? So that really, I think of it in two buckets, right? So you have this bucket of, your business plan and getting ahead from business efficiencies, and then actually leveraging AI related to your technology or your product, right? And the legal risks are very different for both of them. So hopefully that clarifies some of the earlier discussion. What am I putting in ChatGPT, what am I not, is a starting point thinking about, your market size, who your competitors are, product, sourcing, things like that. That's nothing to do with your actual idea or product. So that's an easy place. It's like a yes, don't worry about it, right? Where you can get ahead. Just to give you a global view of IP very briefly, there's really 4 big buckets of IP, right? You have patents, copyrights, trademarks, and trade secrets. So we could spend all day talking about that, and it's something I do all the time. But from a patent perspective, if you put something into ChatGPT or elsewhere, technically almost all of the AI platforms can use that information. That's how they get smarter, right? They use that information. So it is possible that that could be output to a third party, to a competitor. Probably unlikely. Right now, I think the New York Times right now is in a very public battle with Microsoft about this exact issue, because ChatGPT, if you prompt it, will give exact replications of New York Times articles, right? And so the New York Times is obviously not really thrilled about that. They spend a lot of time paying their journalists to do their writing. And so, there's a big battle going on right now about that exact issue in terms of the use of underlying information and outputting it. So there is a little bit of concern on that front. Whether that information ends up into a direct competitor, probably not, right? So, it is a possibility, but probably unlikely. The other thing about disclosing information into a ChatGPT is it is a public disclosure, right? And so the patent system is really designed to incentivize you to make a decision. Look, I'm going to file for a patent, or I'm going to give my idea to the public, right? And so the government has said you have 1 year to make that decision. So as soon as you make a public disclosure, and that could be telling your friends, it could be coming to mHub and using their services here, that is a disclosure. So the first time you disclose your idea, you have 1 year to file a patent application. And that is important for the US specifically. It's one that, the other thing to know about that is outside of the US, they don't give us that grace period. That being said, for startups, entrepreneurs, outside of the US, patent protection is not typically top of the list or a huge concern, right? But just so you know, as soon as you disclose your invention to anybody, any third party, that starts that clock ticking, right? Including into ChatGPT, right? There's a different question, could somebody ever prove that? Maybe, maybe not. I mean, search history is pretty powerful, right? Your internet search history, so that could be used at some point. But the other thing to know, just from an IP standpoint, are trade secrets. So trade secrets really are things that are secret and have value to you, right? Commercial value. So this comes into play. Coca-Cola has one of the most famous trade secrets in the world with their recipe, right? The KFC chicken blend, spice blend. Those are example, the Google algorithm, right? Those are all things that are highly regarded trade secrets. The reason they're valuable is because they're secret, right? Putting something into ChatGPT, it's not secret anymore. Spoiler alert on that, right? So that's something important to know. So if you were thinking, and this comes into play like coatings, right? Maybe you have a certain blend or a coating that you're putting on a piece of clothing, right, to make it odor resistant. Or you have a product, you're putting some sort of Teflon type of surface, right? So if you have some sort of manufacturing process, maybe that's proprietary, you have a certain way of making your product that's new and different, right? That gives you the special sauce or secret advantage. You have an ingredient, formula, things like that. Do not disclose it. That will destroy your protection, right? So there's a little bit of a line there in what you should be thinking about, right? Is this something that's so valuable to me? I really do think it's super commercially important. Don't disclose it, because you can't get that back, right? So then it is no longer a trade secret, and everybody can freely copy it, right? So that's the underlying foundation of intellectual property, right? This is a free market, and if I come up with an idea and I don't do anything to protect it, other people can copy me, right? Through some form of intellectual property.
I use AI a lot, especially my big job and stuff.
Yeah.
Don't be so afraid.
Yeah, so pitch decks are kind of you're trying to meet different objectives. Clearly you're trying to get a lot of money, number one. And so you need to disclose enough about the underlying secret sauce, right? But from a software standpoint, you can typically do that by talking about the functionality, not necessarily the underlying programming, right? Assuming that it is the programming that's making it unique, right? So you can say, hey, I have this software, and here's the end result: higher efficiency for document review or whatever, right? Whatever your software output is. So from a pitch deck standpoint, it's, you're including a lot of statistics about what's making your thing so great, right? So that's your output. So you're really focused on the output part of it. And if you get questions, it's a proprietary algorithm, right? And you could potentially enter into a confidential non-disclosure situation, right, where you're having a more detailed conversation, with technical people who need to know. But as a general idea, for anything that would be highly confidential or you would consider a trade secret, you would not want to be disclosing that in a pitch deck. Yeah?
So if you had a patent, could you still use it? Put your information in one
Yes, yeah, and the takeaway is not don't use AI for sure. So just it's being aware of just what you're putting into it, right? Going back to the other question, right? And so that's where there's these couple of different buckets, right? Market research, sourcing, competitors, all the stuff that Will talked about, that list of questions, almost all of that is great, and that will help you get ahead in organizing your pitch deck, right? Getting your business plan and your business model to a place that you can present to other people, right? And so the flip side is just being careful, right? Or understanding what you're feeding it, and appreciating that if it's something highly confidential, don't put it in there. Every AI platform at this point, you sign that terms of use that everybody just scrolls by and click OK. That says that they can use your information, period. Again, that's what AI is. That's actually the foundation of AI. They are using all the existing information in the world, and they will use yours. They are not, this is not big bad Microsoft coming out and stealing your idea though, right? That's not what this is. It is, however, hey, here's some other information about how this thing works. They're adding it to this billions of documents and information that they have already, and just it's another data point.
Can you talk about the difference between, I think it's important for people to realize, all patents are not the same. A design patent is not a utility patent because...
Yeah, so the other interesting thing, so from a patent perspective, there's a couple of different types of patents, right? So one is a provisional patent application. A provisional patent application is like a line in the sand, right? So if you were going to talk to potential investors, you were really nervous, right? I don't know what's going on here. You might want to file a provisional patent application. That could be everything from your pitch deck to 5 pages. It doesn't have to be complicated. It's never reviewed by the patent office. It's never made public. It's just simply a document we file at the patent office to give you that date, right? And a little bit of comfort that you have that idea. You have 1 year after that to file what we call a utility patent application. And a utility patent application is really functionality of your product, right? How does your smartphone work, right? It has different functionality and capabilities, right? And so utility patents are examined. And just for context, it normally takes 2 to 4 years for those of you who have gone through the process. So don't be waiting around. You certainly are not waiting to talk to your investors until you have your patents. And then design patents cover the look and feel of your products, right? So Apple has about 40 different design patents on the look and feel of the iPhone, right? Everybody who looks at the iPhone knows the sort of the specific shape, right, and aesthetics of it. So design patents, just as a general idea, much faster, a lot less expensive, right? Because it's pictures, right? It's pictures of your product. So those are really the different kinds of patents. That come with provisional patent application. Yeah. Yep.
I have a statement and I have a question.
Sure.
I'm a trademark person.
Yep. Okay.
And I wrote a song.
So trademarks, of all the areas of IP, trademarks are source identifiers, right? We all know when we see the yellow arches, that's McDonald's. We know what we're going to get there. We're going to get a quarter pounder, right? Or fries or whatever your thing is, right? And every McDonald's has that. We know that. And we know that because it's the source and brand identifier of McDonald's. So in terms of early stage companies or inventors, your brand is important and also not necessarily mandatory to get it registered. You acquire some rights in trademark usage just by using your trademark. And so in terms of having something pending at the trademark office, it's the government. They take their time. That's all I can tell you. So if you filed your trademark application similar to patents, it just takes time. So they will go back and forth with you. Sometimes they have some problems with what you filed, right? And they'll work with you to say, we need you to fix this part of it or whatnot. But there's a back and forth process with the trademark office where you will go from just trademark TM, which means you are claiming a trademark use, to trademark Circle R, which is registered. If it's just sitting there and you have to file a document every 6 months, it sounds like what you're filing is an extension, right? Because you can file trademarks on different bases. Whether you can file something called an intent to use. I'm planning on using this trademark, but to move it through the trademark office, you need to submit proof. Right, so it sounds like that's probably just not knowing anything. It sounds like that's where you're at. So on an AI, just going back to the AI part of the conversation, right? There's so many fantastic uses for AI that you guys can implement right now, right? That really are not risks to your IP. It's just being thoughtful about if there's anything that is, really highly confidential. That you would like to retain as a trade secret is really the main thing to be careful of. If you've disclosed, in a lot of detail, something that might be patentable, you have that year time frame too. But again, you have to, for a disclosure to count, it has to be pretty detailed as well. So it's pretty unlikely if you're asking ChatGPT some questions that you've probably disclosed enough to cause issues as well. So.
Is that a good idea?
So I think the question was going back to what we were just talking about, right? How much information you should give or not, right? And so I think that was the genesis of it. So really it comes down to, you don't really want to type in every single detail, right? You can break it up into bits and pieces, right? So the bike example is such a good example of, and you have the buckets, right, of your more business-focused ideas, right? Those are things like what we were just talking about, your product placement, just making your products look better, right? Creating your pitch decks, right? Things like that. Also, your sort of cultivating your different relationships, right? The CRM programs have been using AI for a long time, right? Customer relationship management functions, right? They've been using AI. That's why you guys all get targeted marketing, right? That's why you get emails all the time about different products that you're interested in, and you get them, at the right time. That's because they've been tracking how often you're buying certain products. They know that you're interested in, a new car purchase the week before Thanksgiving or whatever, right? So AI has been used very effectively in CRM and customer outreach for a long time. It's actually one of the oldest applications of AI, that I think most of us can think of and actually understand in our day-to-day life. Not as sophisticated, but it's sort of happening. It's like what I think somebody said, it's here. Right now it's just a little bit more visible, but that's been going on for a long time. So it's really putting AI into different buckets. AI as a business tool to help your business get ahead, and AI as a tool that you might implement in your products as well. So that's something else we haven't spent a lot of time talking about, but enhancing your product with AI as well is sort of the next generation. Or we'll maybe have a separate talk on that one. Right now, anything you generate or create with AI is not protectable via copyright. So what that means is if you are going into DALL-E, creating a new image, you want to use that image on your website, that's okay. But if other people start using that same image, you can't do anything. Because AI created that. So right now the US government says you need to be a human to get copyright protection.
You need to be a what?
Human.
Oh, okay.
Pretty high bar. So humans are the only ones who can get copyright protection. The government also, on the patent side, says AI cannot be the sole inventor, right? So AI itself can't invent something.
Right.
That said, if you give it some information and some prompts, there's a whole standard that we're all going to try to figure out what that means in the next couple of years. But if you're substantially involved, right, you would be the inventor, and you have to be involved. So AI cannot be an inventor and get a patent on its own at this point. So just appreciating the AI tools that you're using and what the implications might be for your IP protection is helpful as well. Realistically, if you're creating photos or images, taglines, things like that, they're not protectable, right? So be a little bit careful with marketing materials, especially if you're creating things to use on your website, or that'll be an important part of your brand, right? Because other people can take those.
Say, AI help me.
Yeah.
Oh, yeah.
Yeah.
You're in trouble, right?
Well, so this is going to be why I have a job for the next 20 years, right? Is because it's hard to show, right? How are we gonna show that, right? Okay, well, you had the substantial involvement. It was not just AI. Maybe we're going to be looking at your history, your prompts, right? The outputs, maybe. I don't know. Those are all legal questions for the next 10 to 20 years. But to have a valid patent, you have to be the inventor, right? You have to be the legal inventor, which means you came up with the idea, you conceptualized it. There's all kinds of fancy legal parts to that. But at the end of the day, it has to be yours, and you have to be the one that developed it, right? You can use AI to assist you, right? But AI can't be the thing that's solely responsible for your idea.
So, but now, if another human help you invent the product,
Yep.
they have to be listed as a co-inventor.
They do. Yep.
Okay, so
Yep.
that can't be a correct.
Yeah. So it's, like I said, AI will be probably a topic for all of us, right? We could have the same discussion every 6 months and the conversation might change a little bit, right? AI is changing every day at this point, right? Especially in the legal world, what's okay and what's not. Yeah, I think, if you think about even something like Photoshop, Adobe Photoshop has been around for a long time, right? You put a photo in, you manipulate it. Nobody is questioning that me as a photographer, that I own the copyright to my manipulated photo. We all put filters on things, right? I'm still the owner of that photo, right? So it's, what's the line that goes between this was my original idea and creation to something totally different?
This is a general question about
Yeah.
patent.
Yeah.
When you have a patent already and
Uh-huh.
you want to add on to what you've done,
Yep.
is that process still the same as when you went to the original, or is it just kind of, how does that work?
So you could file what's called a continuation in part, which is essentially your original patent plus new information. Most people don't do that anymore because there's some real downsides to that. So you would essentially end up filing a new patent with the new information, a standalone. But because once you file it, you can't add to it, right? At least easily, without finding something new. All right. So there's not a bright line test, right? The 60% thing is not like a real thing. It's what it comes down to is if you're starting with something completely generated with AI, it's not protectable on its own. You can manipulate it, but it's a line, right? And it's a grayscale, right? So it's not just going to be once you change 60%. It's going to be when is it different enough, right? That's an open question, and for each product, each picture, it might be different. But the test for that is what we call substantial similarity, right? If you have two people, you're both looking at, this looks pretty similar, right? I mean, in copyright infringement, there's a lot of subjectivity, right? So some of it's just how different or similar it is.
Okay.
Yeah.
When it comes to social media, you got the
You remember we were talking about Microsoft owning your information? I mean, look, the terms of use for YouTube say that anything you upload there, they own, functionally. So you might want to be a little careful about that, right? I mean, it's a very complicated question. That's a little flippant, right? But at the end of the day, posting something on a public site like that, you want to just be careful about the terms that you're doing that, right?
Do you think things will change depending on the outcome of this New York Times versus Microsoft?
Yeah. So this is an interesting to wrap up on, right? So AI leverages existing information. So at what point, if you go back to even in the mid 2000s, everyone had Napster or LimeWire. Everyone's like, great, we can download free music. We don't have to pay the creators, right? We just download free music, and then everyone's like, wait a second, no, we can't. You have all these artists who people are violating their copyrights left and right. The same is true right now, right? In my opinion, all my opinion, but you have the New York Times journalists. I mean, they've been working to get these articles. Why should somebody else take that information and just spit it out, right? My prediction is you will have a licensing model like you have with ASCAP. ASCAP is the global organization that controls music rights and artists. So every time music is played in a restaurant, at a festival, the artists get 1 cent or whatever, right? But there's a global licensing model that compensates creators in the music industry. I think you will see that. And honestly, that's what Google did. That's what a bunch of the big tech companies have done already. Microsoft did not do that. That's why they got sued. So the New York Times has those license agreements with a bunch of other organizations that are using their information. And and I think you can think about it in terms of with the AI platforms you're using. We want good information. We should want them to enter into agreements with the New York Times and not random blogger, right? In terms of the quality of information you're getting, right? So I do think things will change, and I think it'll change from a company standpoint. If you are an AI platform generator, you're using those large language models to train your data, they're gonna have to pay people for that data, right? Or otherwise compensate them, I think.
Fair.
I mean, people can debate, right? And you could say, well, look, it is like we're just making encyclopedias available, right? There's a lot of really interesting questions, right? What are those boundaries? But at the end of the day, there's creators and people that have worked hard to generate that information who are not being compensated.
Creators should be paid. I will go to my deathbed.
Yeah, in a room full of creators, right? So that's a good place to end. That's a good place to end.
I want to thank our presenters here.